Hi everyone, Jeff Marion. Welcome back to my YouTube channel. We talked last week about the lawsuits involving Zantac and the recall of Zantac and ranitidine. Well, what if you or someone you love took Zantac and now has a cancer diagnosis? Can you sue? What does that look like? This video will help you navigate what happens and that particular process. This is one of a series of videos that will help you understand and navigate a personal injury lawsuit. So click on the logo in the corner to subscribe to this channel and see new videos every week. I've been fighting for people who've been injured in crashes, in falls, and by unsafe products such as Zantac and ranitidine for over 25 years. I will help you understand this process, and I will walk you through every step of this particular complicated lawsuit. So let's do a quick recap. Zantac and its generic equivalent ranitidine both contain NDMA, a known carcinogen used in rocket fuel and to give lab animals cancer. So what happens is, for the most part, when the Zantac is ingested or the ranitidine is ingested, it breaks down into NDMA, which then enters the body. The NDMA also can form on the shelf. It can form in the warehouse due to heat. It can form due to light. So even sitting in your medicine cabinet or at the grocery store or at the pharmacy, those pills as they age are starting to break down into NDMA. And as we discussed last week, the amount of NDMA that can come out of one of these pills or regular use of Zantac is over 400 times the daily amount that's allowed by the Food and Drug Administration. So what are the criteria for a plaintiff in one of these lawsuits? There has to be a minimum of 1 year of use and at least 12 months from that first use to the diagnosis of cancer. Okay, so the case is based in the Southern District of Florida. Does that mean I have to hire a lawyer who's licensed in Florida to practice? For multi-district litigation, the answer to that is no. You can have an attorney from anywhere in the country, and that attorney can get admitted pro hoc vice to the Southern District of Florida for the purpose of this particular case. So pro hoc vice is a Latin way of saying for one case only. And this is common in any multi-district litigation wherever it is in the country, because you're going to have attorneys from all over the country bringing these cases. So to make it easier to consolidate all of that, these attorneys can have their cases and themselves admitted for the basis of representing their clients in this particular case. Does it mean that the case will necessarily be tried in the state of Florida? Not necessarily. Sometimes those cases can get sent back by the judge to a federal court where they came from. Now, we can discuss mass tort law or multi-district litigation in greater detail and walk you through the anatomy of that. But let's keep it pretty simple today to talk about Zantac and the process of this particular lawsuit. Now, I told you that there were some developments in ranitidine. And what happened is that the defendants in the case made a motion to dismiss many of the causes of action in the plaintiff's master complaint. The judge granted a number of those motions. Now, the basis for that is what's known as preemption. And what that says is that if there's a federal regulation or federal law that governs that particular claim, you cannot bring a state law claim. Now, why is that important in federal court? Aren't I making a case under federal law? Not really. Let's back up a second. Those cases can be and usually are brought in a state court, in a court in your county where you live. And that's brought under state law that deals with unsafe products. Breaches of warranty is one cause of action. Design defect, manufacturing defect, all of those are generally governed by state law. In this case, what the defendants argued, and those defendants were the ones who were manufacturing ranitidine, is that the federal regulation says that if we're going to manufacture this generic, we have to do it the exact same way that the brand name is made. We cannot deviate. Not only that, we have to use the very same warnings that are on the packaging for the brand name. We can't deviate from that. So you can't hold us responsible. Our hands are tied. The judge agreed with that proposition and has dismissed most of those claims. Now you can still bring a claim under ranitidine. There's still some breach of warranty claims that are available. There's also negligent distribution and negligent storage and some other causes of action. So just because you got ranitidine as opposed to Zantac doesn't mean that you shouldn't contact a lawyer and discuss whether you've got a case. Now, if you or someone in your family or someone that you know has one of these cancers that I've put on the screen here and took Zantac, please contact me. I'll help you get your case registered. We'll help you get the records to prove your case, and we'll walk you through this and we'll fight for you here. If you have questions, leave them in the comments below. Also, like this video and share it on your social media pages. You can also subscribe to this channel by clicking on the logo button in the corner, and we have new videos every Sunday. So until then, I'll see you next week.